Chapter 5, Alternative Dispute Resolution Systems. Here we go. Let's see what we can find. I got just old stuff on there. Kind of a cool chart that doesn't have anything to do with this class, but it's kind of a cool chart. Holler if you want to know anything about it. So it's important to note this, that 95% or more of the lawsuits that are filed, so the lawsuits actually have filed, settle prior to the completion of the litigation process. So that's even ones that have gone so far as to actually file the lawsuit. They still get settled at a very high rate. We're not even counting then the disputes that get settled before the lawsuit's ever filed, which is a tremendous number. So, you'd probably be correct to say that 99.9% of, these types of disputes get settled prior to completion of litigation. Okay, and of course it would depend on what you would classify then as a dispute. If you were arguing over your couple bucks extra that you got charged for your supper and you and the restaurant figured it out, technically that would be a negotiated settlement, but might not really fit our purposes for business law. So conflicts and disputes, right? Conflict leads to disputes, and a lot of times it's just stuff that happens. Nobody intends it to. It's accidents that happen that can lead to disputes. I think we had the topic in the discussion about the wrong roof, and just a miscommunication. All types of things can lead to conflicts and disputes, unfortunately. And fortunately, most of them get resolved, right? So negotiations, right? It's a process used to persuade or coerce. Ooh, coercion. That sounds kind of evil. It is kind of in some ways, maybe. So types of negotiations. First we have positional ones, right? Parties state their opinions. It begins competitively, and it involves some give and take. Okay, and the principle. Both sides have principles, right? Or they positions, I guess, that they want upheld. Okay, so you got workers maybe, and here's got buyers and sellers. Okay, so the seller wants X, wants $100. The buyer says I'll offer 80, right? So we've got a difference, okay? But maybe the seller is willing to come down to 85, and maybe the buyer's willing to go up to 95, right? So we've got a zone of agreement there, and if we can just find a number in that zone, we'll get it solved, right? If if the buyer or if the seller's stuck on 100 and the buyer's stuck on 80, we might be stuck. Even if the seller had come down to 95 and the buyer would go up to 85, we still don't have a zone of agreement then, right? We're going to be at odds still. And think about these positional negotiations. They're very, very common, right? These are probably the ones that we think about. It's like going to a garage sale and dickering over the price of a old wicker basket or something. Or it's wage negotiations that employees and employers have all the time, right? You stake out positions and you do those types of things, right? On the other hand, we can have principal negotiations, and sometimes these have been called interest-based, right? And interest-based negotiations are more, not to say that it couldn't be in wage negotiation, it couldn't be those things, but think more of, maybe contract disputes. And maybe, hey, we're arguing about something that happened in the contract, maybe it turns out it wasn't the contractor's fault. Maybe they couldn't get supplies in on time, and so now they're past the due date and they would like an extension, right? And maybe it's in both parties' interest to kind of settle, come up with some type of a compromise, right? and they've had a pretty good relationship otherwise, and it really wasn't the contractor's fault, but neither should the owner say, or the person that hired the contractor, neither should they suffer. And so, they sit down and they communicate. Maybe they want to maintain that relationship. They talk about their interests. The owner wants to get done as fast as possible. So does the contractor, because he or she wants to move on to the next job, right? And so they compare their interests and they try to get those, taken care of. Might not be in the owner's interest to go hire somebody else, right? Because they get them ramped up, and okay. So they talk about the various options that they might have. The legitimacy of their claims, their side, their options, et cetera, are there other alternatives? And then is there a commitment to the finished product, and so or the finished agreement? Those things are all important then in principal negotiation. So why do we have ADRs? Typically, we follow this line. They're less expensive, not typically, they're always less expensive than trial and appeal. Okay, and we kind of go along this line. We're not going to talk too much about these two in the middle, just because, frankly, in Montana, I'm not familiar with them happening. They might, bigger cities, other venues, I don't know, but I'm not familiar with them in our area. Negotiated settlement, again, is the least expensive, right, and the least time-consuming, least emotional investment. Folks get together, and again, this happens all the time. The next least is mediation, then we go to arbitration, and then ultimately trial and appeal is the most expensive, most time-consuming, the most emotionally taxing, etc. So why do we settle? Okay, costs. And this happens all the time, and you see this. A business weighs that. They weigh those things. I had a buddy one time, and he was sued. His business was sued. He and his business were sued for discrimination. Okay, and he claimed, and rightfully so, he couldn't have discriminated on the basis of the claimant with the claim, because he didn't even know that the claimant was a minority in this case. But in any event, that was the claim. He had insurance to cover those things, and while he wanted to fight the claim, he wanted to fight the suit, the insurance company stepped in and said, "Nah, we're just going to settle it. We're just going to write a small check and agree to settle this thing." And the reason why, they didn't want to pay attorney's fees, they didn't want to pay court costs, they didn't want to pay those things, right? Personal reasons, though. Compromise is kind of instinctive. We don't like trouble. We value the opinion of others, and we don't want that to change, right? Business reasons. If we're going to be in the news a bunch, had that lawsuit taken place, my buddy's business would have been in the news, and etc. Might have been bad for business, and they worry about sympathetic juries. We always worried about sympathetic juries in banking, because banks were always seen as having deep pockets, right? And juries would sometimes vote against them just seemingly for that reason. Major settlements, and these are, I'm guessing this was Vioxx not too long ago, Citicorp. This one's an old one for Citicorp, because Citicorp's paid tens of billions in fines in the last few years over the mortgage crisis that we had, as have other banks. I think I showed you last chapter, a couple chapters ago, that the settlements that the banks have made total in big banks have been over $100 billion. Okay, so this is probably kind of dated information that the book put into the PowerPoint in this case. So let's talk about arbitration, and obviously we're not going up the line. Obviously, we're kind of jumping from negotiated settlements all the way over to arbitration, but arbitration is becoming more widely used, might be a way to say that. And in arbitration, a third party, an arbitrator or arbitrators, can be generally 1, 2, 3 probably not two generally. It's probably an odd number usually. But they make a final decision, right? There can be mandatory arbitration and voluntary. In some states, I don't believe Montana is one of those. I can't say for sure, but I don't believe Montana has mandatory arbitration for certain things. But certainly we do allow voluntary arbitration, and we'll talk about how that happens in a while. And then the final decision is called an award, and it's binding. Okay, reasons we do arbitration is that. Again, go back to that chart. It's quicker and it's less expensive than a trial. Okay, it eases the court docket, so our court system and our government actually favors arbitration. And there's expert assistance in this. Oftentimes, the arbitrators have knowledge of the subject matter expertise, I guess, is what we would call it, right? So it's called a submission, and that's when the parties agree to use arbitration to settle disputes. Okay, they agree to specific matters. Okay, sometimes it might be just salaries. Maybe it's salaries and working conditions. It might depend on the type of dispute that's happening, obviously. But they agree on those ahead of time, and those are the only ones then that will be discussed, generally speaking, in the arbitration. Okay, and the arbitrator can decide, unlike remember we talked about juries generally decide facts. You can request or require or ask that a judge make that decision, but juries generally decide questions of fact, and judges decide questions of law. In arbitration, the arbitrators kind of do both. And there's a trend toward arbitration. We're seeing it in more and more agreements up front. And I think we talk about that in a little bit. Okay, the arbitrators are chosen by the disputing parties, and oftentimes there's three. And the way they would do that is each party would choose one arbitrator, and those two arbitrators then would choose the final arbitrator, right? And again, they have a common law of shop or a common knowledge of that particular subject matter. We hear about athletes, and their contracts may be coming up for arbitration. Okay, well, believe me, the arbitrator knows the laws and knows the rules and those things surrounding that, but that arbitrator also probably knows baseball statistics, knows, a guy that bats 300 with 100 RBIs and 35 home runs and, plays good, is a good fielder, maybe has an idea what that person's worth, right? Besides just too much. So, the authority again is granted by the agreement, and I need to get into that. But again, it can be at the time of the contract, but it can also be later. I'm sure that comes up again, so I'll cover that. So we had the Federal Arbitration Act. I wouldn't worry about the dates, but we do need to know the Federal Arbitration Act, right? It covers any arbitration clause involving interstate commerce. Again, interstate commerce is defined pretty broadly, okay? And it says that the federal government, the preemption, remember the supremacy clause and preemption and stuff, says that that state laws may be set aside, right, under commerce and supremacy clauses. So again, the Federal Arbitration Act really favors arbitration, and they may force states to allow it. Even a state may pass, and that has happened, and it's gone to the Supreme Court. States passed laws that made it illegal, maybe for car owner or car dealerships to require arbitration when they sold cars, and I believe that one went to the Supreme Court, and the Supreme Court said, nah, arbitration's okay. We favor arbitration, and so the state law basically was knocked down. Okay, typical arbitration agreements. You guys can kind of go through these. What I would tell you is that, this says brokerage firm and employee. I will tell you that a lot of employer-employee contracts are starting to include arbitration agreements, so that if there is a dispute over the employment, wrongful discharge, anything like that, it might go to arbitration if the parties agree to that. I get a little irpy about that. I guess it just, bothers me if somebody leaves college and they go to work for XYZ corporation, XYZ huge mega corporation, and XYZ mega corporation has you sign an arbitration agreement when you go to work. Well, you're fresh out of school. You're not going to argue about that. But in a sense, you're giving up a little bit of your legal rights, perhaps when you do that, and making it a little bit easier on your employer if there is a dispute. Now, that said, I don't hear a lot of abuses, coming out of the system. I don't hear of employees getting the shaft, because they had this arbitration agreement. Okay. So awards, again, disclosure findings, not necessarily needed unless it's required by statute or agreement, so it can be kept confidential maybe, right? But the parties are bound by the award. Some of them, the mandatory ones, for sure have to be filed with the, I believe, county clerk of court. The court, again, favors the award in the broad scope of authority. Okay, final on submitted issues, so they do file it with the court clerk, and it can be then enforced by the court in that case. So mandated arbitration, right? More and more states are adopting it. Speeds up the process. There's a lot of qualified arbitrators, and again, not just on the law but also on the subject matter. With the states that are doing it, and again, I don't think Montana has, but they're smaller cases, so maybe even taking the place of small claims courts, and two for a specific subject matter. Again, I don't know of any in Montana, but just as an example, we have separate courts for water rights. Well, maybe we would set up a separate system for water rights that would require arbitration. Could happen. A record of proceedings, when it is mandatory, then they do have to record the proceedings. Procedures, okay. Submit claim. There is a discovery process, but it's minor compared to the trial and whatnot. A lot quicker. Hearing can still take up to 8 months. My guess is these would be bigger arbitration cases. Probably not the landlord-tenant thing. Probably not small ones would take that long. The less than 15,000, I doubt that they would take that long. There we go. Yeah, pre-dispute arbitration. Okay, so again, this is when you sign the contract. The original contract might have an arbitration agreement in it that just basically says if there's any disputes that arise out of the nature of this contract, the parties agree to arbitrate the dispute. On the other hand, it can certainly be entered into post-dispute. So you got a couple parties and they figured out that they can't get along over an issue or issues, and so they can agree to arbitrate it at that time. And both parties might be amenable to that just because it would save lots of costs. Might keep it private. Judicial review. Awards final, findings of fact, law conclusive, and so those are just basic facts about arbitration. But judicial review, and this is important, it's limited. Okay, it's limited. They seldom overturn awards. They kind of rely on the arbitrators and their expertise and those types of things. The only time they do, and it comes up kind of in our next one. I'll get through this part first, though. It can be statutorily mandated, the review. Okay, in accordance with procedural and due process of law. Okay, de novo, a judicial review is if the arbitration had not occurred. So that would be going back and checking to make sure that everything was good, whereas in some cases they might just review and make sure that the proper procedures were followed in going through the arbitration. And those things are included in the Federal Arbitration Act. Nothing major there, but these are the things, right? Arbitration award may be vacated if, and this is a pretty limited list, right? If there's fraud, so maybe one side comes to the table and misrepresents or fraudulently presents evidence and whatnot. The arbitrators themselves are corrupt. Okay? There's misconduct by either parties or the arbitrators, and it exceeds the powers. Okay, it exceeds the power. So maybe they're trying to resolve issues that can't be covered in arbitration. What those might be, I don't know. Okay, but it could be something like that. Mediation, on the other hand, and I used to think mediation, what a waste of time, right? The mediator can't impose a binding resolution on the parties. Mediator can only suggest, but after I kind of saw it in action a time or two, man, maybe it does make far more sense, and I'll tell you why in a bit. But the parties get to agree to that, so they agree to mediators. Okay, it again reduces the court caseload. In this case, there is no judicial review at all. Okay, the settlement is a mutual choice. So the advantage to parties is, of course, they get to determine if they want to pursue this or not, and they all ultimately retain control of the outcome. There's no binding thing forced upon them, and so they have to agree to that. Disadvantages is enforcement, right? There's no enforcement of the mediators. I hesitate to call it a decision, but they're suggestions. Okay, and the selection of the mediator can be difficult and expensive. Okay, qualified mediators might have to come a long ways, especially when we live up here in rural Montana. You just don't. Have you ever met a person, you asked him what he did for a living? He said, well, I'm a mediator. Well, it just doesn't happen too often, right? Okay. The process is informal, so there is no set process, really. Generally, you're going to have some opening statements, right? The mediator's going to kind of set some ground rules, and this is probably after talking with the parties involved, right? The parties are going to review the statement. They start to exchange and discuss options. They might caucus. Now, what really happens in mediators and why it becomes effective is this. It's, just imagine in so many of these negotiations, like wage negotiations and things like that, the parties become tense, the emotions get high, and there can be a whole lot of yelling and screaming, and we just don't get, and finger pointing and those types of things, and we don't get to the issues like we should. And a mediator steps in and separates the parties, sends them each to a neutral corner, if you will, and says, let's approach this a little different way. And then goes to each side, and the emotions have left now. They're not staring at each other. Instead, they're in a room by themselves and with the mediator, and the mediator's just saying, hey, what's the issues here? And how can we resolve this? And each side kind of makes their case, and the mediator shuttles back and forth and tries to find some common ground. And if enough common ground is found, then they can write up an agreement, a settlement. That might be when they caucus. Maybe they're close on some issues, just a few little minor details, and so they might have a caucus where they all get together. Okay. The caucus, I suppose, could be separately also, though with the mediator. Okay, and then they eventually get a written agreement and they sign it. Now, what's important in mediation is that the mediator cannot impose a binding agreement. Okay, and that separates it from arbitration. That's on the test, no doubt, that arbitrators can impose a binding agreement. A mediator cannot. However, in mediation, once the parties sign an agreement, that is binding. Okay, that's binding when the parties do sign that agreement. Mediation is merged, yeah. They use a lot of, and in fact, the president can require mediation if the railroad transportation unions decided to go on strike. The president could order a mandatory mediation process before maybe they could go on strike, and get some mediators in there to try to resolve the issues. Different things like that have happened. So if the parties to a mediation sign an agreement at the end, that agreement is usually legally binding. That's true, right? All the following are advantages of arbitration over litigation, except you'd have to say the right to appeal. Yeah, some arbitration kind of becomes public when it gets recorded or whatnot, maybe the mandatory ones, but for the most part it would be the right to appeal. Okay, again, other ADRs, and I just don't want to spend a lot of time on this because I haven't seen them. I don't think they're in Montana to my knowledge. So there you have it, ADRs in less than a half an hour. I'm getting better.